Good morning, everyone, and welcome. My name is Art Lytle. I'm the president of the Ottawa Region Masonry Contractors Association, and we are happy to sponsor and introduce the construction law update session. Your speaker for today's session are Nadia Oche, partner at Rasmussen Stark Rudy LLP, and John Melia, partner at Kelly Santini LLP.
Good morning, everyone. Just before we start, so we only have an hour today, and I think the way that we'll be able to get the most information out to you is if we wait till the end for questions. And so at the end, we'll reserve some time. If you have any questions, please let us know. Also, I'd just like, by way of show of hands, who's here in terms of general contractors? And subcontractors? And owners? Okay. So I just wanted to get a sense of sort of what our audience makeup was. So for today, the topics we're going to touch on is the new Federal Prompt Payment Act that has come into effect. We're also going to go over the proper invoice and notice of non-payment under the Ontario Act. We'll also touch on adjudication in Ontario. And we'll finish off with the impact of the decision from the Supreme Court of Canada in the Sudbury matter with respect to the definition of an employer under the OHSA and how that could have an impact on employers and owners on construction projects. So I'm going to start with the Federal Prompt Payment Act. So as you may be aware, the Federal Prompt Payment Act has come into effect as of December 9, 2023. Now, for projects that were in existence prior to that date, the Act will not apply until a year from December 9, 2023. So I'll use the Parliament Hill refurbishment that's going on. That project obviously has been going on for many years and will be continuing into the future. So that project technically will be subject to the prompt payment provisions of the Federal Act as of December 9, 2024. Now, that being said, the way the Act has been drafted is the federal government can decide to exempt any project. There's no criteria they have to meet. It is entirely within their discretion. So they can decide at some point this year, you know what, that Parliamentary Hill job, not going to be subject to the prompt payment provisions of the Federal Act. And in terms of, so here in Ontario, because obviously in Ottawa especially, we have a lot of federal government projects. Federal government is one of the is a main source of work for a lot of the contractors and subcontractors in the province and in the city. So for the projects that are in Ontario, the way the Act is drafted is the Ontario provisions of the Construction Act will apply as between GC and sub, and then between sub and sub. However, where the contract is between PWGSC and the GC, the provisions of the Federal Act are going to continue to apply between the federal government and the GC. So now on these projects where the prompt payment provisions of the Federal Act are going to apply, you're now going to be dealing with two acts as the general contractor. That changes, however, if there's an intermediary between the two, such as BGIS. So BGIS often will be the service provider who administers the contract on behalf of the government. They're the ones that are paying for the services. If BGIS is in the middle there, and I'm using them because they're frequently involved on these projects, the Ontario Act will apply to the project as a whole. So just to give you an example, I'm going to use there's a federal government building that is on River Road if you're coming in from the south end of the city. If there was to be a construction project at that building, if BGIS is involved in that project, then the Ontario, and they designate that project will be subject to the Federal Act. In that case, the Ontario Act will apply for prompt payment and adjudication as between the BGIS, the general, and the subs. So you're dealing with your usual timing of 14 days from the owner if it's going to be a non-payment, 28 days for payment if there's no issue as to payment, and then 35 days GC to sub to pay your subs. That same building on a river road, if BJIS is not involved and the federal act applies, in that case, you're going to have, as between Public Works and the general, it's the federal act that's going to apply. Under the federal act, the government has to provide notice at the 21-day mark if they're not going to pay you. But because the Ontario Act is going to apply between GC and sub, that has an impact, because under the Ontario Act, as the GC, if you're going to flow that payment, that notice of non-payment down to your subs, you have to tell them on the 21st day. So that same day that you get your notice of non-payment from the government, you have to make a decision that day. Am I flowing that down to my subs? So you don't have time to think about it. You're going to have to tell them that same day. Thankfully, payment under the federal act is 28 days, which is the same thing as the Ontario Act, and then you would pay your sub on the 35th day if you're going to be paying them, or provide them a notice of non-payment because maybe you've got a dispute with your sub. So that's one thing to keep in mind in terms of if you're working on a federal project, you could run into a situation where you're having to navigate both acts. With respect to adjudication, sorry, I'm going to take a step back from that. Firstly, so projects where it straddles both provinces, and that impacts obviously this area because we've got Ottawa and Gatineau, and the Alexandra Bridge that is going to go out for tender, I believe, in 2025. The federal act would apply to that project if the government decides to have the federal act apply. So if it straddles two provinces, then it's the federal act. It wouldn't be the Ontario Act. And the government may decide that they're not going to use prompt payment on that. That'll remain to be seen.
What's your prediction, Nadia, in terms of the government's uptake to actually use it? Because in Ontario, it's mandatory, must use. The feds have retained the right to say which projects can or can't use. So what do you think?
I think for all of the existing projects that are out there, the federal government's going to say, no, the Prompt Payment Act is not going to apply. And I think for large projects like the Alexandra Bridge, they're going to say, no, it's not going to apply. And to be honest, they're probably going to be very slow in the uptick in terms of having the Federal Prompt Payment Act apply, because it takes a lot of time. And we even saw it on the Ontario side. I remember when it was coming into force, I was speaking to in-house counsel at the City of Ottawa, asking him what measures that the city had put in place to make sure they were going to be abiding by that 28-day payment period. And he said at that point, they had done nothing. They had done nothing to get themselves up to speed to be in line as of 2019. And I expect the federal government is going to be the same. They're going to be very slow, and they'll probably, for the first year or so, be saying, no, the federal act won't apply, the federal act won't apply, and it'll continue like that for a period of time. Eventually, they'll start getting more and more projects that will be subject to the act, but I see it as being very slow. Going back to having two systems. So if you are in a situation where your contract as the GC is with PWGSC as opposed to with someone like BGIS, if you have an adjudication, your adjudication is going to be under the federal act with the government. But if you've got an issue with your sub, you're going to be under the Ontario Act. And where I see that is going to be quite problematic is if you need to consolidate an adjudication. So let's say one of your subs has commenced an adjudication for non-payment, or there's an issue with respect to a change order. We'll use the change order example instead. So sub says, I'm entitled to a change order. They issue a notice of adjudication against the GC because it should be a change order. That issue as to whether or not it's a change order involves the owner. But if you're in a federal government project and your contract is directly with PWGSC, you can't bring the government into the adjudication in Ontario. You can't do a consolidation. So in Ontario, and we'll get into this later, But in Ontario, as the GC, you can consolidate a claim with the owner and a claim with the subcontractor to have the issue heard together. You can force that as the GC. That is your right under the Act. When you're dealing with where there's no service provider, BGIS being a service provider, where there's no service provider in that contract, you're not going to be able to force that consolidation. So you may end up in a situation where you have an adjudication with your sub on a change order issue. The adjudicator in Ontario says, yeah, you know what, that's a change order. You've got to pay your sub $200,000. You have that same adjudication with the government on the federal side, and the adjudicator in that matter goes, no, it's not a change order. You're not going to be able to get paid by the government for that. You're now in a situation where you have to pay your sub that money, and now you're going to have to start litigation to get that money back on the basis of, no, it wasn't a proper change order, and you should have never been paid. So the introduction of the Federal Act, while good, because hopefully it'll increase the speed at which contractors are being paid, because I know sometimes the federal government can drag its heels in terms of payments, it's still going to cause problems for the time being until maybe some changes are made and they align the two a little better. So that'll remain to be seen. Now, as always, you still have no lien rights. So the Federal Act does not change that. You do not have any lien rights on a federal project. That hasn't changed. In addition, the Federal Act will not apply to NCC contracts, Canada Post contracts, defense construction contracts, EDC contracts, and I'm just naming sort of, the industries that we see here in Ottawa where you would have a construction project with some of these crown corporations. The Federal Act will not apply to those contracts. So if you have a contract with the NCC to do some construction for them on the Ottawa side, Federal Act will not apply. So again, for Ottawa contractors, the Federal Act, some good, some bad, and it may cause some problems down the road. That'll remain to be seen. Just want to make sure I've touched on everything. Yeah.
To clarify for architects and engineers, is the Federal Act apply in the same way as you were referring mainly to general contractors? Just like the Ontario Act applies to consultants, does the Federal Act also apply to professional consultants?
I don't believe it does because it speaks of contractors and subcontractors, and the definition of contractor is a party that contracts with Her Majesty or His Majesty or a service provider under which that party is to perform construction work. So
Because it does apply in Ontario.
no, and I appreciate that. And construction work is defined as the supply of materials or services, including the rental of equipment for the purposes of a construction project located in Canada. The difference with the Ontario Act, it actually speaks of design work. The Federal Act does not speak of design work.
So you have a situation where Aegis is doing work, and you said that it applies to the Ontario, then do we have rights under Aegis?
No, because the Act itself does not apply to architects and engineers. So you're still in the same situation that you're in now, which is you, as an architect or an engineer, you do not have coverage under the Federal Act, only under.
And I guess it's not intended to ever?
That remains to be seen. They could change it down the road if they see that, there's a discrepancy between the acts. But right now, as drafted, it's only drafted for contractors, subcontractors, suppliers, subcontractors. All right. I'm just double checking before I turn it over to you. Yeah, no, that's it. So I'm now going to turn it over to John, and as I said, he will be dealing with proper invoice and notice of non-payment.
Good morning. Just to pick up a little bit on where Nadia left off to transition into proper invoice and notices of non-payment. The new legislation is out there. Lawyers are looking at it. The industry is looking at it. There's a lot of gaps, as Nadia noted, and things that maybe people didn't quite think about yet. So there's going to be some more discussion on these topics as we go, and we'll see how they get sorted out. But I agree with Nadia that in terms of the uptake for projects, I suspect we'll see a slow uptake, and they'll roll it out on some smaller projects with fewer players, less administration and oversight from the feds to try and iron out some of the kinks. So, if any of you end up being the guinea pigs, please let us know, because we'll be interested in how we iron out some of these details. Two of the issues, though, that are going to come up, whether you're in the Ontario or federal system, whatever, the two most common issues that come up daily about the legislation. One is the proper invoice. And what we've noticed in terms of the proper invoice is that people aren't paying enough attention to making sure their invoices are indeed proper. And the Ontario Construction Act clearly spells out the absolute requirements you need for a proper invoice. There's no real magic to this. The contractor's name and address, the date of the invoice and period when the services were provided, information identifying the authority in the contract to support the services that you're seeking, right? Whether it was a change order or whatever details you can provide to highlight that. The description of the quantity and services that were delivered, the amount that's payable, and then the name and contact information of the person to whom payment is to be sent. Now, those are in most invoices already. Where people are getting tripped up the most is that the statute also says, and any other requirements that are in the contract. And this is where, at least what we're seeing, what I'm seeing most often is people not ensuring any of the other requirements within the contract that the owner or the procurement authority has specified are being included in your invoices. And so you're submitting invoices, you're not looking. They may be paying these invoices that aren't proper. And then one day, all of a sudden you get the notice of non-payment or not the notice of non-payment, but the notice that your invoice isn't proper, and you start scrambling because it starts putting you offside on getting your money out. So one of the key things that we would like everyone to take away is pay attention to the contract requirements for a proper invoice. It's very easy at the front end of a project to set your invoicing up to make sure you're filling in all those boxes appropriately, so when your invoices are going in, they're not getting sent back to you for non-payment because of a technical irregularity. Most of the things that you're always going to see, obviously, you're going to need stat decks that are for the current period. You're going to need up-to-date WSIB certificates. All right, that's easy. We've been doing this forever. But you're going to start to see other nuances for different projects that owners are going to want included in those invoices. And you'll have to tweak your forms and adapt and make sure your invoices that are going up to the owners and from subs to the contractors all the way through the pyramid are proper. One of the nuances, at least that, and you and I have spoken about this, is that who decides ultimately if it is a proper invoice or it isn't a proper invoice? And at the moment, right, it's all left to the owners and the consultants. And what do you do if you're in a fight over what is or is not a proper invoice? There really isn't any clarity in the Construction Act as to what you do, other than to struggle through the process and try and negotiate your way around making sure your invoices are getting approved and not punted back down from people looking to create issues. And it'll be interesting to see how, when we start talking about adjudication, is you submit your invoice, they say it's not proper, you say it is. Can you fight about that in an adjudication or can't you? And then when it starts to get even trickier is I've got an invoice in my hand from a contractor or from a sub. We've determined it's not proper. You say it's proper. Should the owner or shouldn't they deliver a notice of non-payment? And again, the statute is unclear on what do you do in that circumstance where you're fighting over the propriety of the invoice. And what we're seeing, at least what I've seen, is notices of non-payment. And this is where I wanted to kind of segue into. I think the biggest problem right now is people not delivering notices of non-payment. Owners to contractors, contractors to subs, whatever. And the statute says if you do not deliver the notice of non-payment, you shall pay that amount. And so effectively what the statute has created is a interim process where you pay now and fight later. So someone delivers an invoice and they bury a $5 million delay claim in their invoice. And before the legislation was enacted, you would have just struck that out and said, I'm paying the $250,000 of work you did this month. I'm not paying the $5 million delay claim. Okay, strike it out. They pay the $250,000. Everything moves along, and we say we're going to, we'll fight about the delay claim. Well, should I have delivered a notice of non-payment? And you start to get into a lot of these novel, twisted arguments over whether or not that invoice was proper and all of these things. But out of an abundance of caution, why not deliver the notice of non-payment within the days and say, I'm not paying that $5 million, and here's why. And save yourself the agony if adjudication happens of having to defend the reason why you didn't pay the $5 million and you didn't deliver the notice of non-payment. So the two biggest problems we're seeing with respect to the statute right now is people not delivering proper invoices, people misinterpreting what the proper invoice requirements are under the contract, and consultants and owners struggling to determine whether or not it is or isn't a proper invoice sometimes. So that's issue one. And it's an issue that with some administrative front-end work, you can probably save yourself some agony in terms of getting paid on some of those invoices. Especially the larger ones are the ones where people are going to start looking carefully to make sure it's proper. But issue number two, obviously, is the notice of non-payment. And the second part I would make about the notice of non-payment, one, know your timelines, because if you deliver it on day 15, you're out of luck. If you deliver it beyond the 7 days that you're required to deliver it, you're out of luck. Second thing is, make sure you know what the notice of non-payment says. It's not enough to simply say, I'm not paying. So you need to specify precisely why and give enough detail so that the party can know precisely what it is that they need to do to address the non-payment issues. And it's most telling, especially when owner delivers the notice of non-payment to the contractor. Well, the contractor may have been working on multiple divisions of work, right? They may have all sorts of different sources of divisions of work proceeding at the same time. Wouldn't be enough for the owner to simply say, notice of non-payment, I'm deducting from the account $1 million with limited particulars, because then the contractor receives that notice of non-payment. How are they supposed to then deliver their notice of non-payment to the subs that are actually affected? Because the way the statute is designed to work is that once the owner delivers the notice of non-payment to the contractor can then say, electrician, I got knocked down because they are saying you are not 35% complete, you're only 20% complete. And so the progress draw was deducted accordingly. I'm deducting your account accordingly. Similarly, there were deficiencies on maybe some of the framing work. And so framing contractor, I need to deduct you accordingly. And so if the pyramid is to work effectively and money is to flow and money is to be deducted from accounts going down, only the parties affected should actually be deducted, and everyone else should get paid in the ordinary course. And in a perfect world, it would work. We don't live in a perfect world, and we don't live in a world where people are accustomed to doing particularized notices to people every month about why they're making deductions. They would rather just get on the phone and talk about it, and then expect that the contractors are going to get on the phone with their subs and work it out, which is the way it's always worked in the past. Difficulty being now, if your notice of non-payment is non-compliant with the statute, it gets punted. And you pay now, and you fight later. And so I'll give you a dramatic example. We actually have seen an invoice submitted, and in that month, the value of the services provided for the month of work was in the order of magnitude of about $500,000. And buried in that invoice was a matter that had been already started for arbitration, a delay claim on the project that had been kind of simmering and brewing for $5.8 million. So $500,000 worth of work was performed, $5.8 million delay claim buried in the invoice, no particulars on the invoice. Consultant, in their wisdom, struck out the $5.8 million delay claim, sent the invoice back to the general contractor, advised them that only the $500,000 would be paid, didn't tell the owner that this wasn't a proper invoice, which probably would have been the smart thing to do, is kick it right back to the contractor saying not a proper invoice, which it technically didn't meet the requirements for a variety of reasons, notwithstanding the fact that the invoice was for a delay and didn't have any of the particulars in it. So there is no notification that it's not a proper invoice. Kicks it over to the owner and says, only pay the $500,000 work. Owner pays. Owner pays and says, sure, that, boom, pay the $500,000. Contractor turns around and says, you didn't deliver notice of non-payment within 14 days on the $5.8 million one line item delay claim. Starts an adjudication. We're going to talk about adjudication momentarily. Matter is now proceeding to an adjudication, and the statute says, if you don't deliver the notice of non-payment, you shall pay. Owner is now staring down the barrel of a gun of, do I got to cut a check on a $5.8 million disputed delay claim and then fight about that later? And the answer is maybe, probably. Strictly interpreted, that statute says if you do not deliver the notice of non-payment, you must pay. Pay now, fight later. And dramatically, similarly, this could happen to contractors. Your subs put in a line item, you strike it out, you send it back, you pay them what they're actually owed, say we'll deal with that other issue later, that disputed change order, that extra that we haven't quite valued, that change directive work that hasn't yet been determined. Contractor might have to pay now, fight later, because they didn't deliver a notice of non-payment. Similarly with your material suppliers. They invoice you for things and it's not in accordance with what you were expecting, or they say they delivered quantities and you say, no, those aren't the right quantities, whatever. If you don't deliver the notice of non-payment, you may be required to pay now, fight later. And we all know that once that money leaves your account, getting it back is not an easy adventure. Once you've made that payment, it's not an easy adventure to get it back. And any number of things can happen in between the time that you pay and then the fight later. Now, we love the fighting. I make most of my money fighting with people and trying to resolve these tricky little issues and sorting it out. Now, I will say this. My example, the legislation is called the prompt payment legislation. Well, it's the prompt payment regime. It's not the wrongful payment regime. And this is where I'm starting to get tripped up over it. And what I'm seeing is form now starting to dictate over substance. And what I'm also seeing is circumstances where that can happen. Form dictating over substance, and people taking advantage of people's good faith and good efforts and not playing by what we would consider good business practice. So while my example is a circumstance where an unscrupulous party could put someone over the barrel, the only remedy you have, if that happens to you then, is potentially, and we're waiting to see how the courts will deal with this, is an application to a judge to say equity must remedy this situation. And the one thing that we're really good at, lawyers, is basically saying equity trumps all. And what that really means is the judge can pretty much do whatever they want. They're not bound necessarily by what the legislation says. If they think it's an unequitable and unjust result, they can fashion a remedy to fix that problem. here's your problem. It's been tried recently. And it was a very similar circumstance to the one I described. And the court did give leave to the person who was affected, the person who had to pay now, fight later. But the court said, you made two mistakes. We gave you leave and you made two fatal mistakes here. Mistake number one, you didn't seek what we call a stay. Technical issue, legally speaking, where you basically have to ask the court to stop that process. You didn't ask for that in your relief, so that's a problem. But the real problem that they said was, while we want to help you, and we may have wanted to fix this problem for you, you cannot escape pay now, fight later. You should have posted that money with us. You should have showed up here immediately with the check and said, please let me put this in court and let me fight about this later. This would be so inequitable for me to pay them now and fight later. But you're going to be out of that cash. Now, so the court punted them and said, you can't fight about this right now because you didn't ask for the stay and you didn't offer to post the money in court, so we're kicking you out. Now, that was a $40,000 pain in the ass, excuse my language, dispute. I wonder what they would do with a $5.8 million clearly wrongful payment, and whether they would then extend the olive branch. Well, why don't you just pay now? But the interesting thing will be, what do they do with these circumstances? And certainly to my mind, judges are all about trying to get things right and try and make sure people are dealt with equitably and justly. And if they see a circumstance that is clearly in their eyes leading to an absurd result, they're going to want to step in. The difficulty will be, will they, under the current regime, change the pay now, fight later? Probably not. Will they compel you to pay into court? Probably. And will they change what the legislation and what the adjudicators are doing, right? And one of the difficulties that we're all facing is, and we'll talk about adjudication momentarily, is you're getting these decisions. Now, that is a decision by an industry-recognized expert that judges are now being told they should show deference to. And so when we talk about the adjudication in a moment, it's something everyone has to think about. Should I go down this road? Is this really in my best interest? Or do I elect for some of the more traditional remedies? Yes, there's a question here.
In that scenario that you described, where the consultant crossed it out and passed it to the owner, is the responsibility incumbent on the owner to advise, or can the consultant be delegated that authority?
So under the statute, the owner must deliver the notice of non-payment. Statute is very clear, right? It must come from the owner. The consultant doesn't have the authority to issue the owner's. Now, if I could see a circumstance where contractually the consultant is the agent of the owner and could theoretically probably slide into that obligation. I think the more interesting issue is the consultant potentially liable there to the owner for not having advised them of their obligation to deliver a notice of non-payment in this circumstance? And it gets very complicated because we can all foresee a circumstance where I'm the consultant and I'm trying to administer this, right? Every month that those bills are coming in, every month I'm reviewing them. I don't have a lot of time. I'm working them up. I'm telling the contractor, here's your problems. I'm telling the owner, you should be paying this. We want to keep the money flowing. And I didn't say, oh, by the way, it's not a proper invoice. I basically just marked it all up. And I didn't tell the owner, oh, by the way, you should probably send a notice of non-payment because I'm just trying to keep this ball rolling. And the owner knew or ought to have known of their obligations. And then the question becomes, did the contractor, by accepting my money on a struck out bill, acknowledge that the bill was actually the strikeout now and not their original bill? So there's areas where you can fight about these things and debate these things. But now all of a sudden us crafty lawyers are sitting up here saying, Mr. Consultant, you're on the hook potentially for a $5.8 million wrongful payment because you struck it out and you told me to pay and you didn't say that the contractor agreed with this. And so now the consultants might have to wear some of this potential liability. And so we pay now and we all fight later. And we have a party with multi-party litigation and arbitrations that could go on forever, and lawyers who can come up with all sorts of novel ways of making sure this thing takes a long time and costs a ton of money.
But in the, I think it's 21 days, you said, you require for notification.
14 under the, from owner to general, it's 14 days.
Quite often, the consultant may take 5 to 10 days.
We saw a case yesterday where we got the notification of a reduced payment, and we had literally hours to finalize a notice of non-payment with the owner and make sure it got out on time. So this isn't unusual, you're correct. Now, prompt payment was designed so that these things would happen quickly. In practice, it's creating problems and obstacles. And certainly I would say that owners are going to be, as this statute evolves, owners are going to get tougher on their consultants to make sure these reviews are done quickly. And we'll see how, the change starts to flow. It's only going to take a couple of people to get burned and cost them money before everyone starts to wake up to, we got to do this. And
I was at the AGM for the Toronto Construction Association a couple of weeks back, and the minister came and did a presentation, the engineering minister, with respect to the construction active comp payment. They're in the process right now of taking comments from the construction industry on improvements that as you're speaking to right now to tweak. They want to have it released by October, so if there are comments there,
And we know that these comments are flowing up to them. One of the difficulties is obviously legislation takes time to pass through all the different stages. And so by the time they go from comments to actual legislation, you've got to live through this. So it could happen imminently. It could take years. You never really know. And when we talk about the last issue today, the Sudbury case, that's another one where you never know what's going to happen. Now we're starting to roll out of time on this topic, and we kind of want to move to adjudication. So if we'll bear with us for a moment, I'm going to hand it over to Nadia to start to talk about a little bit of what we've seen in terms of the uptake of adjudication and what you should be aware of in terms of your adjudication options.
Sorry, before we move on to adjudication, I just want to give another example of what can happen if you don't issue your notice of non-payment, and this is more from general down to sub. So as a general, you've got a sub who's supplying materials to your project. There is a deficiency in what they have supplied. You've given your sub notice of the deficiency, you've asked them to correct it. They don't correct it. You now, because you have obligations to the owner, you have to correct it. So you're now incurring money to correct that default. Sub has issued payment. They did the work, they've issued their invoice, they've done the work. You don't want to pay them because you're now incurring $500,000 in costs to rectify that default. If you do not issue your notice of non-payment within your 35 days, as you are supposed to, they bring an adjudication, they will win on a technicality. So now you've paid the $500,000 to fix the default that they refused to fix, and now you're going to have to pay them $500,000 on their invoice because you failed to deliver your notice of non-payment. So as between general and subs, very, very important. If you're not going to pay your sub because you have a beef with them because of supply, because of deficiencies, poor performance, make sure you provide them with the notice of non-payment. Because if you don't, you could pay twice. And then you'll have to chase your sub. And unfortunately, once the money is in the hands of the subs, sometimes, not all subs, some subs don't have the financial wherewithal to pay you back once you get that judgment at the end of the day. So you may never be able to recover that money. So very important as a general, if you're not going to pay your sub because of a deficiency, make sure you are sending out that notice on that 35th day so that you're not having to pay twice.
Can that notice be something as simple as email?
Nope. No. It has to be on the form. It has to be on the form. And the OCA has the Word version of all the forms because I've sent them to them multiple times after presentations that we've given. So certainly you can get them from the OCA. They're online as well. You must use the form and provide as much information as possible as to why you are not paying, because sending an email, and I agree with you, the subs know full well why they're not being paid. But if they can rely on a technicality and leverage out that $500,000 because, you know, if it's a small sub and maybe they're on the verge of insolvency, they really need that money, they're going to do what they can to get that money. And so send out the notices. If you're not going to pay 35 days, send out your notice.
I would just add there, form is trumping substance, and so you can't rely on that. Your letters, your emails, it has to be on that form. And it should be on everyone who is in the administrative offices that's dealing with this stuff, should have that notice of non-payment form and have it ready to go, because it has to be on that form. It's right in the legislation. I think it's an unfortunate reality, but it is there.
And I can tell you, I tried the argument of, well, here's all the emails where we told them why we weren't paying them.
Yeah.
And the adjudicator didn't buy that. So you're not going to, you can be imperfect in the completion of your form. So maybe you haven't perfectly filled out the form. Adjudicator will probably give you a pass on that. Email is not sufficient. I tried it. Adjudicator said, no, email isn't sufficient. It's got to be on the form. So have those forms, make sure your administrators, whoever is dealing with that aspect of the project, that they have copies of those forms.
But you can't email the form.
Yes, the form itself, you can attach it to an email and send it off. That's not a problem. It's, you've got to have the form. All right? So we'll move into adjudication, and so we don't have a ton of time left because I want to leave some time for any questions. And we've sort of sprinkled the topic of adjudication throughout the presentations today. A couple of things to bear in mind, and I've mentioned it already. One is it worth it to go to adjudication? And the reason I say that is when you're, sometimes, based on the value of the claim. So if your claim is $500,000, the amount that you're going to pay to the adjudicator is quite significant. And you don't get any of that back. So if it's claim between GC and sub starts an adjudication, you as the GC have to respond. You're both paying equal share of the adjudicator's retainer, but if it's a $500,000 claim, you could be paying $30,000 to the adjudicator. That is the face that I make every time I get the quote from the adjudicator as to what they want to be paid. And so you have to, and also consider, is it a complex claim? Is it one where nobody's going to be satisfied with the outcome, and it's just going to lead to further litigation down the road, and you're going to be spending more money? So you have to look at, is it something that I really want to adjudicate? Because there are downsides to adjudication. Maybe instead of adjudicating, you decide, we're going to do a med-arb. And it's going to be, the decision is going to be final and binding. We're going to give ourselves more time to put together our materials. We're going to give ourselves more time to make sure we have all the evidence before the arbitrator. And then we're going to try to mediate it first. And if we can't, then we'll arbitrate it. I call them quick and dirties because you get it done in a day, 2 days, you're done. Parties feel like we've had an opportunity to put our claim forward. We are satisfied with the decision, and yeah, we'll pay it. And you move on, and you're not having to go through litigation later on down the road. That's one way to deal with it. But if you're going to go down adjudication, and if you are going to be the one initiating the adjudication, make sure you have everything ready to go before you hit submit on that notice of adjudication. I have one, and I see Kara at the back because she was on the other side of it. My client, unfortunately, was filling out his notice of adjudication, and he didn't realize that you can't just start it and come back to it later, and so he hit submit, and he wasn't ready to hit submit, but now you've started the clock. And it's a very tight clock, because once you've hit submit on your notice of adjudication, claimant, you've got 5 days to put all your documents in, and then the respondent usually has 7 days, 7 to 10 days to respond to that. Everything's supposed to be done within 30 to 40 days. So if you are going to be initiating that notice of adjudication, make sure you've got all your expert reports if you need an expert report. You've got all of your materials. Everything is put together in a package, and you've got a summary of what the issue is and why you say you're entitled to be paid before you even start your notice of adjudication to get that out to the other side.
So what I would add on adjudication, I agree with Nadia entirely. If you are the party initiating, it is absolutely in your best interest. You've got a strategic advantage. Use it. Get your whole case ready as if you were going to literally go to the hearing tomorrow. If it's that ready, then you should proceed. And until it's that ready, don't give up that strategic advantage. It's crazy. So that's issue one. What I would add to what Nadia said, adjudication is quick and efficient and can be a manner in which you can settle a sticky issue during the course of a project, and as it could be in the best interest of all parties. But once you start to look at it really carefully, you start to say, what makes sense for a quick, efficient, mid-course resolution of an issue? Do I want to put a huge issue on the table for a party who's going to have very little time to review it, right? The adjudicator has very little time to review it, has to make a decision, and you never know which way they're going to go. And we're seeing people start to want to put these mega cases and issues in front of adjudicators, and at least from my perspective, I'm cautioning, don't do it. Don't do it. The adjudicators are not well equipped to deal with this and to really give it the consideration it needs. Neither party will be happy with the result. And so deciding which cases actually make the best sense for adjudication is the most important business decision you're going to make. Your lawyers will do what you tell them to do, obviously. But at least from what I'm seeing, the ones that make the most sense, you got to dispute a change order. And you're trying to fight over whether it was or wasn't in the scope of work, whether it's, means and methods. Okay, we can't agree. Let's go to adjudicate that issue. That makes sense. Single issue, pretty narrow. Is it in? Is it out? Let's have an industry consultant, expert, whatever, make a determination. We have a change directive. We can't agree on the value of the work. All right, let's go to adjudication and see if we can sort that out. Why do we have to wait till the end of the project and have all these arbitrations, whatever? These single, discrete little issues that would help the process move along more efficiently make a lot of sense. Slapping in an invoice for, a mega delay claim and then issuing a notice of adjudication and trying to resolve that in 35 days is not in anyone's best interest. Not the owners, not the contractors, not the subs, no one's. Because the adjudicator is never going to be able to really make the informed decision that they need to get to the bottom of what's happening here and work through all those issues. But technically, if you invoiced for it and they delivered a notice of non-payment and you wanted to, you could. But now you're going to have to live with that decision and the consequences of it. And in the case where, let's say the owner wins, gets it struck out, and you're the contractor, the owner's going to be waving that around for the next 3 years while you're in court saying, I got a decision from the industry expert. And you end up with a judge looking at it going, I may have to pay that deference. Right? There's an industry expert who said, no dice. Similarly, on the other side, owner could get dinged pretty bad on an adjudication, and they've got to stare down that decision. So my advice is, on the adjudication, it's a great way of settling single issue, discrete issues that are not revisiting the entirety of the project or mega issues. And you can get through that pretty efficiently and make the projects work. But I'd be very cautious before I decided to hit somebody with an adjudication. We're going to move over now to the City of Sudbury case. We don't have a lot of time, but we do want to touch on this. In fact, John DeVries wanted us to make sure we touch on this case. And so for all of you that may or may not be aware, City of Sudbury case is probably, it's a seismic change in the occupational health and safety requirements on a project. if time permitted, we could do an entire hour on the case. So I'm just going to quickly summarize. But basically, this is a case that went through all levels of court. Started at the trial division, went through the first round of appeals at the Superior Court, then went up to the Ontario Court of Appeal with a split decision, then went up to the Supreme Court of Canada, and in a very unusual decision, 4-4 split. And because it was a 4-4 split, we were short a judge for a variety of reasons. But because it was a split decision, the Ontario Court of Appeal lower decision remains the law of the land. So you've got a case right now where 4-4 split in the Supreme Court in terms of what the obligations are of parties on a project from an occupational health and safety perspective. And so without going into the entirety of the case, what I will say is this. Okay. Everyone on a project right now technically is an employer, potentially under the current Supreme Court of Canada decision. Everyone on a project potentially has liability for the entirety of the health and safety of a project. Now that's being a bit extreme. I mean, even the majority or the decision makes clear that it's going to be dependent on a whole series of factors. But where we used to have the constructor, the contractor, there was a constructor on the project, they are responsible for health and safety. Health and safety usually stops and starts with them and the person whose forces were actually in the incident. Now, you've got a circumstance where, in the Sudbury case, the owner was deemed to be an employer. They had forces going to the work to do quality control, and the Supreme Court agreed that under the definition in the Occupational Health and Safety Act, the fact that they weren't the constructor was not relevant because they were still considered an employer who hired a contractor and had employees going to the site, and therefore they had health and safety obligations. And that where the decision then twists, it says, so you are on the hook potentially because you're an employer under this definition. And now we're going to assess your due diligence defense. And so now more and more risk is being created. And what does that really do on a project? Well, for generals, owners are going to be on your back when it comes to health and safety. For subs, and I gave the example earlier to Nadia, you can see circumstances where you're all employers, and now all of a sudden, am I responsible if I'm the drywaller working right behind the framer? So we're kind of working over top of each other in the same workspace, associated work. Potentially, yes, I might be responsible for their forces and their health and safety obligations because they're in such close proximity to my workspace that I have to be cognizant of it all. And all of a sudden you start to see the net expanding to where you were only responsible for your forces to now you're potentially responsible for other people's forces. And so you'll have health and safety obligations that could land you in a proceeding because something happens on the site. And I think the liability is now up to $2 million an incident, and some potential for jail time still. It's not an insignificant thing. So I will say this. Lots of people have very different opinions on this. This is public welfare legislation, right? In the Sudbury case, an innocent bystander got killed crossing the road. That kind of fact is going to move a judge, right? And they're going to want to find liability wherever they can to try and remedy the wrong. And the city of Sudbury got tagged with liability there, potentially. They're going back to trial to see if their due diligence defense holds up, but they're going to get potentially tagged as an employer on a job site for health and safety obligations. So what I would say is this. Everybody on the job, see something, say something, do something, right? For the time being, that is your only chance at avoiding liability if something happens on a job. If it's in your proximity and you see it and it doesn't seem right to you, you say something to a supervisor, you say something to someone on site with a position of authority, you record it, that's do something, and then you send it as a follow-up. Short of that, your obligations for due diligence start to fall away by you saying, well, I was relying on other people's expertise. Secondly, all of a sudden, you start to have to look at your own health and safety protocols internally, and looking at your partner's health and safety protocols. So if you're working with a general, you want to make sure they're up to speed on health and safety. Owners, and this is more for the generals, be aware. Owners are going to be on your case. Institutional and commercial owners are going to be on your case. They are going to be on the job sites with their clipboards, and now health and safety is going to be top of mind because this is all they're hearing about right now in all of their settings. So I believe the legislation is going to be revisited. But as we said earlier about the legislative changes that are coming potentially with the Construction Act, this has been going on now for some time. Supreme Court released its decision in December of 2023. And right now, I think it's in all your best interest to be using your OCA, using your CCA, using your owners associations, your subcontractor associations. You should be telling them all, get onto the members of provincial parliament and get this clarified. The way things were done prior to this wasn't so bad. We had a constructor, health and safety rested there, the sites were safe and secure, and there was order in an otherwise, chaotic world right now. So I certainly think it's in everyone's best interest to start to lobby to get this legislation changed so that we can get back to the way things were being administered. Because right now you've just got this net potentially. And here's the only safety valve is, as the court said, well, the people charging have discretion and prosecutors have discretion. I don't know how many of you have dealt with charging officers, but I don't think they're going to exercise much discretion. If they see something that needs to be charged, they're going to charge. And then you've got to hope that the prosecutors are going to breathe some sensibility into the process rather than drag you through trials for cases where you had almost no interest or issue in the relative space that's being determined. Nadia, sorry, I know you wanted to jump in there too.
It's okay. I'm used to you going on. So just to cap this off, in terms of your due diligence, because, look, the inspectors in Ottawa with the Ministry of Labor, some of them are great guys, dealt with them repeatedly over the years. Some of them are a little more overzealous in terms of their charging. As an employer, you'll probably get charged. The key is, can you avoid the conviction through your due diligence? What due diligence means, not, it wasn't my fault, it was his fault. Never a defense. That will never be a defense. You need to be able to show, here's everything that I did to make sure that the site was safe. If I'm an owner, I've given the constructor power not only over his own subs, but also my own forces that I brought in. Because on this project, the general had his forces, but I also had some interior finishing forces that came in. Contract said that the general is going to be the overall constructor. That's great, not a problem. But make sure that as the owner, so that you're not in the situation that Sudbury's in, you've given appropriate power and control to your GC to kick your own forces off the site if they're not complying. Another thing, we'll use the Sudbury case. The fence wasn't there. It's a pretty obvious thing. If your employees see that the construction fence hasn't been put up, notification needs to go to the GC. Work is to stop until you've put that fence up. You failed to comply with your health and safety obligations. I, as the owner, am not going to be liable for any delay caused by the fact that I'm telling you you have to stop until you put that fence up. This is on you. Have it all documented in writing so that if you do get charged and you call up my office or you call up John's office and say, I've been charged, what can I do? I always say, send me everything you've done with respect to health and safety. Send me all your due diligence information. Because then I'm going to call up the Crown and I'm going to say, look, you've charged my client as an employer. Here's all the information in terms of their due diligence. And sometimes, depending on the Crown, some are more reasonable than others, they'll withdraw the charges and they won't move forward. But only if we can show them that they will not be successful at the end of the day. So fine, they'll be able to meet the first test, which is you were the employer and an accident occurred. They've met that first test. But now we have our due diligence, and you're not going to get that conviction, so withdraw the charges. I've been successful in getting Crowns to withdraw charges when we've been able to demonstrate that they're just not going to be successful at trial. And if they have someone else they can go after, a constructor, so in this case, interpaving, if they have someone else to go after and they know they're not going to be successful against you because you've demonstrated your due diligence, the reasonable Crowns will withdraw the charges, but you have to set yourself up so that you can show the Crown, don't bother because you're not going to be successful. And the Crowns don't like to go to trial knowing that they're going to lose. They prefer knowing that, you know what, I've got a fair shot at this, so I'm going to continue with it. But if we can demonstrate that they're not going to get that conviction, they'll withdraw if it's a reasonable Crown. So really key is making sure you've got your documentation and your proper due diligence in place so that at the end of the day, even if you get charged, we can avoid a conviction.
And just a final note on health and safety, obviously, is probably one of the most fundamental parts of a construction project. Construction projects are not safe places, people. And the last thing you want is one of your co-workers, one of your brothers, your sisters, your family members to not go home at the end of the day. And so we all take health and safety very seriously because at the end of the day, we all want to get home to our families and our friends and continue, right? It's just a job. It's just a project. And so shortcuts shouldn't be taken. And as I said earlier, see something, say something, do something. Now, final note, because we were asked to make sure, even though Nadia and I are not part of the authorship team of this publication, we're going to plug it anyway. A Layperson's Guide to the Construction Act, Bill 142. It's at the OCA desk. You should all pick one up if you need it. And if you spot anything in there that doesn't make sense to you, we'll be happy to answer the questions about that for you, not rather than the authors, but we'll leave it at that.
And
Thanks.
just for everyone, at page 38 of the book, they actually have the link on where to get the forms. So the link of where to get the forms online is there for your notices of non-payment. So if you take nothing else from this, that link should be in your bookmarks, should be in the bookmarks of your pay people, so that they have those forms available to them to send out if you're not going to pay. So we'll take a couple of minutes for any questions that anyone may have.
You mentioned that on federal projects, the federal government can actually abstain from invoking prompt payment provisions. How do I know as a contractor whether they will or they won't? Do they do the time of tender, or do I need to send them a letter and ask them?
So they are required under the Act to tell you if the Act will apply, and I'm assuming it's going to be in the instructions to bidders. It'll be in that tender package. They'll advise you this project will be subject to the Federal Act. If it is not written in there, they have exempted it, but they are required under the Act to tell you if the Act applies.
Yeah, and so the Crown has to tell the general, and subs are entitled to ask generals for confirmation.
Not in Ontario. So the way they've drafted the Act, if it's an Ontario project and the government has told you the Federal Act is going to apply, so the feds have to tell you the Act is going to apply. But now, because we're in Ontario, you no longer have the obligation as a general to tell your subs that the Federal Act is applying. It's a weird exemption that they've created. I don't quite understand why, but as a good general, you're going to tell your subs in any event, but you no longer have that obligation in an Ontario project.
Just one other question too about proper invoice. If I'm a trade contractor and I submit what I consider to be, or what is considered a proper invoice, because the tender documents don't require a lot of documentation, and that's submitted to the general contractor, and the contractor obviously will submit all the items on the project, which might include M&E, which actually breaks down, plumbing fixtures and so on, and the consultant decides to notify the general contractor that it's an improper invoice. Can they do that? Can they consider the whole invoice improper, or do they only have to consider the portion?
So I'll give my answer and then John will give his answer, because I don't think we have the same opinion on this. So when the consultant is looking at the proper invoice, the consultant is looking at the invoice of the GC. They're not evaluating the invoice of the sub. And the definition of proper invoice in the Act is the invoice as between owner and contractor. So as between GC and sub, you may have requirements in your subcontract of what you want to see in your invoices from your subs, but that is not something that the consultant will concern themselves with. They're only concerning themselves with do I have a proper invoice from the GC in accordance with what it says in the contract? And so if they're rejecting your invoice because of something from your sub, in my opinion, they're wrong, because that's not what they should be evaluating.
I don't necessarily disagree. I think depending on what the prime contract says constitutes a proper invoice is the only criteria that the consultants should be looking at. In terms of a subcontractor's invoice to a contractor, though, you're going to see more and more contractors dropping down the provisions that they're obligated to comply with. So if the sub's invoice doesn't comply and it gets included in the package that goes up to the owner, and then the overall package is affected, you're going to see consultants refusing to say that that's a proper invoice, the GC's invoice, and it gets rejected. The problem is, what do? Right? There's really no mechanism designed in the Act to then address it, other than potentially fighting over whether they're right or wrong, which is never in anyone's best interest. So practically what's going to happen is the invoices get kicked back down to you, and you've got to rejig them and redo whatever they want, resubmit, and get it all kind of administratively done. Whereas in the past, they would have just said, okay, look, we're striking this out or whatever. You'd fix it on the fly. It just creates a bit more of a hassle until someone finally says, okay, proper, now money can flow. So right, wrong, or indifferent, trying to get these things squared away so that the forms tick all the boxes is in everyone's best interest.
Technically, the GC has an obligation to notify me that there's an improper invoice.
Yeah.
Right? Because he's received notice from the owner. So automatically, the only choice I have is to give him notice that it's wrong, that my invoice is proper, because all I was supposed to do was include building one wall, whereas everything else is quite a bit more onerous. And then I've got to go through the cost of adjudication for something that black and white.
Sometimes the law is not the most efficient way of doing things. So the best of intentions does create sometimes unfortunate administrative problems. But by and large, right now, what we're seeing is, at least if people are following the statute, money's flowing a little faster, and the rules of the game are a little bit more clear, right? I mean, if the GC is not going to pay the subs for whatever reason, in the past, you really didn't have any clarity. You had to kind of trust them. Now, there's a mechanism, at least for you to see, well, I wasn't paid, and so you're not getting paid, and here's the dispute that we need to resolve as to why $300,000 was knocked off of, on the masonry side of the project. So theoretically, there is a process that at least puts some clarity in there.
Being cut off.
Sorry.
Thank you, Nadia and John. On behalf of OCA and our speaker gift sponsor, J.D. Brule Inc., please accept this gift as a token of our appreciation.